Hello friends, welcome back to my channel. My dear friends, in the last two videos we have learnt about the kinds of suits and the jurisdiction of civil suits. Now, from now on we will be learning how to prepare plaints. Okay, my dear friends, the plaint has not been defined in CPC or civil rules of practice, but section 26 subsection 1 says that of CPC says that every suit shall be filed by presentation of a plaint. What is plaint? Friends, if you need to make an application to any government authority, you write in a white paper or you write in a prescribed pro forma. Likewise, you need to file a paper with stamps before a court of law with all the particulars of your case. That is called the plaint. And the person who files that plaint is called the plaintiff. Okay? My dear friends, Order 2, Rule 1 of CPC says that a suit shall be framed so as to afford a ground for final decision on the subjects in disputes and to prevent further litigation in respect of such disputed subjects. Okay friends, meaning you have to file suit in respect of all of your claims. Likewise, Order 2, Rule 2 says that if you are seeking so many claims, more than one reliefs, you should claim all the reliefs. If you omit any one relief, you can't file another suit for another relief in future. But if you take permission of the court that you are omitting to claim that relief in the suit, then you can file subsequent suit. That is Order 2, Rule 2. Okay? And for example, my dear friends, if cause of action arises, you may have different causes of action. You need to join all the cause of actions to file a comprehensive suit. You can't file suit for one cause of action and you can't file another suit for another cause of action in future. That is Order 2, Rule 3. Okay, my friends, before preparing a plaint, you should bear in mind the provisions of CPC, that is Order 26, Section 26, okay, Order 6, Rule 3, okay. Let me write it for you. Section 26 of CPC, subsection of just now how to present a suit by, how to file a suit by presentation of a plaint. Okay. Then Order 6, Rule 3 of CPC. This Order 6, Rule 3 CPC plus Order 2, Rules 1 to 3, Order 7, Rules, okay, plus Appendix A of CPC. You need to keep all this in mind while preparing a plaint to be presented before appropriate court. Okay. Order 26, Section 26, subsection 1 says that every suit shall be instituted by way of presentation of a plaint. Okay. Order 7 deals with plaints. Okay. What contents the plaint should contain. Okay, we will be dealing in a little bit time. Okay. And now, just now we discussed about Order 2, Rule 1 to 3 to prevent further litigation and to claim all the reliefs and to join causes of action, etc. And Order 6, Rule 3 says that while preparing the plaint and the written statement pleadings generally, you should take into consideration the forms, models of plaints and written statement mentioned in Appendix A of CPC. Okay? Okay, friends. Friends, I am going further, keeping in mind all these provisions of law in my mind. Okay. The order 7 rule 1 says that the plaint shall contain the following: name of the court, in the court of the Honorable Junior Civil Judge or Senior Civil Judge or District Judge, etc. Name of the station. Okay. Next, OS number dash of 2024. Next year it will be 2025. Okay. Between D. Venkatesh plaintiff and S. Kaleemulla defendant. This is called the small cause stated. Okay. Next is subheading: plaint filed on behalf of the plaintiff under Order 7, Rule 1, read with Section 26, Subsection 2 of CPC. Okay, friends. Actually, we will be filing the plaint in the courts of law under Order 7, Rule 1 of CPC. Okay, Section 26, Subsection 2 says that the facts mentioned in the plaint shall be proved by affidavit. Therefore, you need to file separate affidavit along with the plaint. We will be discussing later. Okay. And paragraph number 1. Description of plaintiff. D. Venkatesh, son of D. Vittal Rao, aged about so and so particulars. Next, number 2. Description of defendant. S. Kaleemulla, son of S.K. Nizamuddin. Okay, this. And under the description of the plaintiff, because the plaintiff must have engaged an advocate, that may be you should write a statement here. The address of the plaintiff for the purpose of service of notices, summons, etc. is that of his advocate Sri Veeranjaneyulu. For example, these are the only examples, my friends. By the time of presentation of the plaint, there will not be any advocate for the defendant. Therefore, here you write the statement, the address of the defendant or defendants plural for the purpose of service of notices, process, summons, etc. is as mentioned above. Okay? This is. And from para 3, my dear friends, the contents of the facts of your plaint, real facts of your plaint begin. Okay? The contents of the plaint should always be in third person, my dear friends, not in the first person. The first person should be used only in affidavits. In petitions, in plaints, you use only the third person, the plaintiffs, the defendants, like this. In affidavits, I, so and so. Okay? Let us take the example of, my dear friends, money suit. From now on, I would be dealing from para 3. Okay, friends, para 3 of the plaint. This is money suit, money recovery suit. Here begins that the plaintiff submits that the defendant borrowed an amount of rupees 1 lakh on dash date from the plaintiff and executed the promissory note which is hereby filed, undertaking to repay the amount with interest. Okay. Number 4. The plaintiff submits that he orally demanded the defendant to repay his amount, but the defendant did not pay. Or if you issue a legal notice, you had already issued a legal notice, then the plaintiff issued a legal notice dated through his advocate to the defendant, demanding the defendant for repayment of the amount with interest, but the defendant failed to do so. Therefore, in the same paragraph, therefore, the plaintiff is constrained to file this suit for recovery of money. Okay? My dear friends, if if you claim any exemption in the law of limitation, then you should write how your suit is within time, though it is barred by limitation. For example, insanity or minority or prosecution, false prosecution of legal proceedings in wrong forum. Those can be excluded under the provisions of the Limitation Act 1963. If you for example, if you had to file the suit in a particular case, but unfortunately you filed the suit in another court, and therefore you can claim for exemption of the period of prosecution of the legal proceedings in another court, wrong forum. Okay, you can claim it. Next, my dear friends, next number 6 is paragraph relating to cause of action. Here you write like this: the cause of action for this suit arose on when the defendant borrowed 1 lakh rupees from the plaintiff and executed the suit promissory note dated so and so, undertaking to repay the same with interest, and on when the plaintiff issued a legal notice to the defendant demanding the promissory note amount with interest, and when the defendant failed to reply the legal notice or failed to repay the amount, and on all such other date or dates which are within the jurisdiction of this honorable court. Okay, here cause of action also comes, plus you are also claiming that the particular court has jurisdiction. My dear friends, the jurisdiction of courts is based in respect of money suits or immovable properties based on the peculiar jurisdiction of the court, or where the defendant resides, or where the promissory notes or contracts are executed. Okay? And next number 7, court fee. You write like this: for the purpose of court fee and jurisdiction, the suit is valued as follows. Okay? The amount due under the suit promissory note is 1 lakh, and the interest accrued on this amount from date of promissory note to particular date before filing the suit or on the date of filing the plaint, so and so. Let us say, for example, 20,000, and total amount is 1,20,000. And in the same paragraph below you write, and the plaintiff hereby pays an amount of rupees so and so under section so and so of Court Fee and Suits Valuation Act. Each state has its own Court Fee and Suits Valuation Act, I believe. And the plaintiff hereby pays the ad valorem court fee. Ad valorem court fee means proportionate court fee. In all the money suits and suits for specific performance, you have to pay the court fee as per the consideration passed under the promissory note or the check or the agreement of sale or sale of contract of related to immovable property. Next, you claim the relief. It is therefore prayed that this honorable court may be pleased to grant a decree in favor of the plaintiff and as against the defendant, clause 1, directing the defendant to pay the suit amount with agreed contract rate of interest at so and so percentage and future interest, and to grant cost of the suit to the plaintiff. Okay? And dear friends, in the next episode we will be seeing the other kinds of suit. If you have not subscribed yet, please kindly subscribe my channel. If you like this video, press the like button, and if you have any comments, please put up your comments, I will reply.